Please unmute yourself.
Good evening, sir.
A very good
My
evening.
Sir, my name is Ekamjot Kaur.
Wait for a question, Ekamjit. Wait. We have not asked you to introduce yourself, right?
No, I'm sorry, sir. The voice came from that side. Please introduce yourself. So I thought maybe there is some connection issue.
Maybe. Yes, please
Let
introduce.
us start it. Okay, start it again. Please introduce yourself.
My name is Ekamjot Kaur. I belong to a small town, Kurali, in district SAS Nagar, Punjab. I have done my BA LLB from University Institute of Legal Studies, Punjab University, Chandigarh.
In which year you did your LLB?
So in the year 2023.
So this is your first exam of judicial services.
Yes, sir.
And you qualified the mains and appearing for interview, right?
Yes, sir.
Good to go. And what about your family?
Sir, in my family, there's my father, my mother, and I have an elder sister.
What are they doing?
Sir, my father is an assistant engineer in PSPCL, and my mother, she is a homemaker.
And your sister, ma'am?
Sister, sir, she is a BDS doctor, and she's married. She's married.
She is dentist. She is dentist, basically.
Yes, sir.
Ma'am, why do you want to become a judge?
Sir, actually, I believe that judiciary is a profession that gives you opportunities to learn and to grow every day. Moreover, sir, it is one of the most respectable professions and one of the best available options in the legal field. In addition to that, sir, my uncle, that is my Chachaji, he is a judge. So since I was a child, I have seen him working towards this profession and I have always felt inspired by him. So all this has motivated me to be a part of this field.
Why you should be selected?
Sir, I believe that I am well suited for this job because I have the ability to take decisions. I am calm, composed, patient, and I believe that I'll do my best whenever if I am given this opportunity with your blessing, sir.
So at present, where is your Chachaji posted?
Apologies, sir. Just a minute, sir. I have a problem with it. Yes. Yes, sir.
At present, where is your Chachaji posted?
Still not audible.
I'm audible to you, Ekamjot.
Ekamjot, you are audible to us. Are we audible to you? Are we audible to you, Ekamjot?
Apologies, sir. I had a problem with the earphones. Now you're audible, sir.
So
I'm
now
really
we are
sorry.
audible.
Yes, sir.
So, Karanji, पूछिए जरा.
At present, where is your Chachaji posted?
Sir, he's posted in Jalandhar,
As a?
Chief Judicial Magistrate.
Okay. So, is there any situation when a CGM can exercise the jurisdiction of sessions judge?
I am unable to hear. Actually, the voice is.
Now I'm audible to you.
Some voice issues.
Now fine, Ekamjot, I'm audible. Is it okay now? Is it okay now?
Okay, no. Yes, sir.
Okay. In any situation, can a chief judicial magistrate can exercise the jurisdiction of the sessions judge?
So may I take a second to think upon it?
Yes, please.
Thank you, sir. So maybe the situation where the chief judicial, yes, so when there is an application before the session judge and the post of the session judge, the seat is vacant or the session judge is not able to discharge his duties because of some reasons, then firstly, either we'll see that whether the additional session judge is there, then he's given the charge to take over if the application is important. However, if the additional session judge is also not available, then it is for the Chief Judicial Magistrate to deal with that application.
So, under which section this is mentioned?
Sir, I'm sorry, I'm unable to recollect the section at the moment.
Okay. So, which subject do you like the most, Ekam?
Sir, it is Indian Evidence Act, sir.
Okay, what do you mean by this star witness?
Star witness is basically who is considered to be the main witness in a particular case. On whose
What is this rustic witness?
Sir, rustic witnesses are basically the villagers and the laborers, mostly illiterate people. They are the ones who are called rustic witnesses.
Which of the provisions of the Indian Evidence Act deals with relevancy of facts?
Sir, relevancy of facts is basically dealt with in section 5 to 55 of Indian Evidence Act.
Okay. What kind of facts are relevant under section 7 of the Indian Evidence Act?
So section 7 of the Indian Evidence Act makes relevant those facts which show the occasion at which the fact in issue or the relevant fact happened.
Okay.
Then,
what kind of facts are relevant under section 5 then?
So section 5 is basically the general section which provides us that in a suit or proceeding, only those facts will be relevant which are made relevant by the provisions of Indian Evidence Act itself and of
So basically section 5 is not providing any kind of relevancy of facts.
Sir, I believe we can say that it says that the matters in issue and the relevant facts are the ones that will be relevant.
By the provisions herein after provided, that is from section 6 to 655.
Yes, sir.
So we can say that there is no fact which is relevant under section 5.
So the rest of the facts derive their relevancy from section 5 itself.
But section 5 gives you a right to produce the evidences of fact in issue or a relevant fact.
True, sir.
Right. What is this artificial presumption?
So artificial presumptions are basically the presumptions of law which are used, we use the expression artificial presumption in contradistinction with the natural presumptions. We say natural presumptions because they are based on logic. However, artificial presumptions are the ones which we are compelled by law to take. So these are basically the presumptions of law, and these can be rebuttable as well as irrebuttable. The rebuttable ones are called shall presumes, and irrebuttable ones are called conclusive proofs.
Okay, can we rebut conclusive presumption at any stage?
So, in section 4 of the Indian Evidence Act, it has been stated that in the case of conclusive proof, no opportunity is to be given to the other party to rebut the same.
But what about section 112 of the Indian Evidence Act?
So, if we talk about section 112 of Indian Evidence Act, there if we want to rebut the presumption, the only option that is available is that the person has to prove that he did not have access. So, it is only non-access that can dispel this presumption.
So how many sections are there in Bharatiya Sakshi Adhiniyam which deals with this kind of presumption, conclusive presumptions?
So apologies, sir.
How many sections are there in Bharatiya Sakshi Adhiniyam which deals with conclusive presumption?
So 112 is there, section 112. 113 has been deleted. Then there is 41 of Evidence Act. So there are 2.
Okay.
Ma'am, generally the presumption is in favor of the plaintiff or the defendant.
So generally the presumption is in the favor. So may I take a second?
Yes, please.
So it may be taken in the favor of the plaintiff.
And ma'am, in criminal side, prosecution or the defense, in whose favor there is a presumption?
So it is in the favor of prosecution.
And then what is the meaning of this line? I'm innocent until proven guilty. Isn't there is a presumption of innocence in favor of an accused?
Yes, so this is one of the basic principles of our criminal jurisprudence, that the accused is presumed to be innocent unless proven guilty. So
then how come there is a presumption in favor of prosecution?
Yes, so when we take these presumptions, in these presumptions, an opportunity is well given to the accused to rebut these presumptions. So he has an opportunity to.
Ma'am,
Yes.
presumption of innocence is already with the accused.
Yes, sir.
So who has to rebut it?
So the presumption of innocence is in the favor of the accused. It is for the prosecution to rebut that. Yes, sir.
So the presumption is not in favor of the prosecution.
Yes, sir. It's in the apologies, sir. I stand corrected, sir.
Can you give me any example in where in any case or any law the presumption is in the favor of the prosecution and it is the accused who has to rebut it?
Apologies, sir. Could you please repeat the question?
Can you give me an example of any law in which in which the presumption is in favor of the prosecution and it is the accused who has to rebut it?
Yes, sir. I have to name a separate law, or it can be from
Yeah,
Evidence Act itself.
any.
Sir, in the Indian Evidence Act itself, there is Section 114A of the Indian Evidence Act, which says that when in a prosecution for rape, a woman states in her evidence that she did not consent to the act of sexual intercourse, then in that case, the court shall presume that she did not consent. In that circumstance, it is for the accused to rebut the presumption that has been taken.
What is the difference between onus and burden of proof?
The burden of proof is basically that never shifts. However, in case of onus of proof, it is the burden of adducing evidence. So during the course of trial, the onus of proof keeps on shifting. That is, the burden to adduce evidence keeps on shifting. But the general burden always stays on the prosecution, that is to prove the guilt of the accused. That is burden of proof.
So the example which you have just given, when upon whom the burden lies and upon whom the onus lies.
So the burden lies on the prosecution itself, but here now, once the presumption has been taken by the court, the onus will be shifted to the accused.
To rebut the presumption.
Yes, sir.
And do you know anything about check bounce cases?
Apologies, sir.
Do you know anything about check bounce cases?
Check bounce? Sir, I have quite a limited knowledge on the subject. What I know is that they are dealt with in Act in Section 138.
All right. Ma'am, can a person who has been summoned as an additional accused under Section 319 file an application for discharge?
An accused someone. May I take a second, sir? To think
Please.
about 319. Yes, sir. A person who is summoned under 319 can file an application for discharge.
Now, what is the scope of power of a magistrate or a session judge while hearing application for discharge? And how is it different from the scope of power which is enjoyed while deciding an application under 319?
While deciding the application, sir, I couldn't hear the last word.
Under 319.
Under 319. Yes, sir. So, if we talk about the general onus in the case of discharge, so if we begin with Section 319, there the onus is that the person has to. Just a second, so may I take a second? So, in the case of Section 319, we do not have to prove that the person is guilty beyond reasonable doubt. That is, we do not have the standard of conviction if we want to implicate the accused person. However, the standard that is required is greater than the one that is required at the stage of framing charges. But
now stop here.
Yes.
Here. When once the judge has exercised his mind and exercised the threshold,
yes,
which is more than what is required while deciding an application of framing of charges,
yes,
then can it not be assumed that the person who has now been summoned as under 319 has already crossed the required threshold of charges?
yes, sir.
And why he can be allowed to file a discharge application?
Apologies, sir.
The threshold of 319 is higher, discharge is lower.
Yes,
Higher threshold is all, there is no need to file. He cannot be allowed.
yes, sir. Apologies, sir. I stand corrected, sir.
And what is de novo trial?
What is
de novo trial?
So, this is basically once the trial has taken place, Then when the trial, after that, it is to be conducted from the very beginning. That is called the de novo trial.
Ma'am, can it be done after passing of judgment by the court?
After passing of the judgment, so if the appellate court passes an order, then in that case, it can be conducted.
Is it within the power of the appellate court to direct retrial?
Yes, sir. It is in the power of the appellate court.
Will it not be in violation of Article 20?
So that is not double jeopardy, because in the case, that is the proceedings which were initially conducted, those proceedings will no longer exist. They will be obliterated off the record. So in that case, it is not going to amount to double jeopardy. Moreover, these are not fresh proceedings. They will be the continuation of the ones that were continuing earlier only. But now the trial is to be conducted afresh.
But ma'am, trying one person twice for the same offense.
No, so for a appellate court to exercise the power of directing retrial, firstly, they have
Under which section is this power of retrial is provided?
So if we talk about CRPC, it is section 386 of CRPC, in which gives the power to the appellate court to order this retrial.
Can in revision this power be exercised?
The power of ordering retrial, sir?
Yes.
Yes, sir. In revision, the power of retrial, yes, because the section 386 also applies to revision by virtue of section 401.
And can in that retrial the final judgment be changed from the one which we had already been given?
Which had already been given previously, sir?
Yes.
Because firstly, we'll set aside the judgment that has already been given. The appellate court will set it aside, and only then the court is going to order a retrial. Not when the judgment is already there and without overturning the judgment, then the court cannot order the retrial. Then it will be double jeopardy.
Can you please explain it again, ma'am?
Sir, what I meant was that if the matter goes to the appellate court, then the appellate court can set aside the sentence that has been passed by the lower court, and the court can even annul the conviction. And in that case, the court has the power to order a retrial if the court is satisfied that the trial has not been properly conducted. So it is in this sense that the court has the power to order a retrial.
Okay, last question from my side. What is section 392 of the CRPC?
The section 392 CR. May I take a second, sir?
Anji.
So 392, as far as I can remember, it deals with the finality of the judgments that are passed by the appellate appellate court. It deals with the finality of the judgments. The judgments are final except in cases under Chapter 30, that is, the revision is allowed. Then there is section 377 and 378. Except in those circumstances, the judgment of the appellate court is final.
Ma'am, section 392 is procedure when judges of Court of Appeal are equally divided on the issue.
Apologies, sir. Apologies, sir. So when the judges are equally divided on the issue on a particular question then they are to refer the matter to a third judge in order to obtain their opinion.
Is it binding upon the third judge that he has to follow the dictum which is being the dictum of the judge who is in the favor of the accused?
No, sir, it is not mandatory.
Please, if one judge has come to an opinion that the man should be held free, another judge has come to the order that he should be held guilty, is it in any manner is mandatory upon the third judge that he is to follow the dictum of the one who is holding the person as free or supporting the accused?
So as far as I can answer, I don't believe that it is mandatory for the judge to. The judge can form his own opinion on the basis of evidences.
Now, what if there is no conclusion? If the judges are not able to decide as to whether the person should be acquitted or concluded, should they go it in the favor of the accused?
Yes, sir. Then because there is presumption of innocence in the favor of the accused, then it should be an acquittal only.
All right.
Ekamjot, have you read any recent judgment passed by the Honorable Supreme Court?
Sir, recent judgment, I haven't had the opportunity to go through the entire judgment, but I am aware in general.
Okay, what is this dissenting opinions in the judgments?
Yes, sir. Basically, whenever if I take the example of a recent judgment itself, like State of Punjab versus Devinder Singh, it has been a 6:1 judgment. That is, 6 judges have been in the favor of the decision, and one judge has given a dissenting opinion.
So
So
what's your views on this the role of dissenting opinions in the judiciary? Is it good or bad?
so I believe dissenting opinions are very important because whenever the judges have an opinion, they should be able to express the same. And moreover, in past also, we have seen quite many instances where the dissenting opinions have subsequently become the law of the land with the changing with this development in the society and the change in mindsets. For example, the infamous dissent of Justice Khanna that became the law subsequently. So I believe dissenting
What
opinions.
was that famous dissent, man? What was the famous dissent?
So the famous dissent was in the case of ADM Jabalpur versus Shivkant Shukla. That is basically considered to be the dark phase of the Indian system. So basically, in this, on
But are you aware of the fact that Mr. Khanna has eventually lost the post of CGI?
yes, sir, I am aware
Do
about it.
you do you know who superseded him?
Sir, it was just. I'm sorry, sir. I'm not able to recollect the name, but yeah, I am aware that he was superseded.
Last question: who is the current Chief Justice of Punjab and Haryana High Court?
Apologies, sir. I'm unable to recollect that. I know it is Justice.
Not an issue.
Justice from MP High Court. I know that, but I'm unable to steal Justice. I'm unable to recall the name exactly. So,
No issue, you can. कब है आपका
Justice
इंटरव्यू
Shiv
कब है?
Nagu.
sorry, sir.
इंटरव्यू कब है आपका?
29th को है, sir.
29th को है.
Yes.
ठीक है, काफी टाइम है. टाइम फॉर फीडबैक एकमजोत. एज सच मुझे नहीं लगा कि आपको कोई फर्दर इम्प्रूवमेंट की रिक्वायरमेंट है ना. कुछ प्रैक्टिकल क्वेश्चंस में मे बी सर ने कुछ सिचुएशन बेस्ड क्वेश्चन पूछे तो मे बी वहां पे थोड़ा बहुत आपको वर्क करने की रिक्वायरमेंट है. लो आपका बहुत अच्छा है ना. हमने काफी सारे क्वेश्चंस पुट किए एविडेंस से, सीपीसी से. यू आर गुड इन योर लॉ. एनर्जी है आपके अंदर, कॉन्फिडेंस भी है, बैलेंस टोन है आपकी, और सबसे इम्पोर्टेंट चीज की आप ऑनलाइन इंटरव्यू में भी ड्रेसअप होके प्रॉपर आए इंटरव्यू देने, तो इट शोज योर डिसिप्लिन, राइट. सो यू आर गुड टू गो फ्रॉम माय साइड. बेस्ट विशेस.
Thank you, sir. Thank you so
सर
much.
एनीथिंग यू वांट टू ऐड प्लीज सर?
कौर जी, दो बातें हैं बस छोटी सी. पहला तो बिना पूछे आप अपने चाचा जी के बारे में मत बताइए.
All right, sir. Sure.
बिकॉज बहुत बार ये ख्याल आ जाता है कि जब घर में एक दो लोग जज हैं तो तीसरे की क्या जरूरत है. ठीक है,
All right, sir. Sure.
है ना. बिकॉज बहुत लोग ऐसे हैं जिनके घर में एक भी नहीं है, तो सोचा जाएगा कि यार अगर ये उनके बराबर 19-20 का फर्क है तो उनको दे दो
Sure, sir.
प्रैक्टिकली. ठीक है ना. अनटिल अनलेस इट इज आस्क्ड, डोंट टेल.
Sure, sir.
एक. दूसरा, मैंने एक चीज नोट करी, पता नहीं आप वो वहां करेंगे कि नहीं करेंगे, जब आपको आंसर नहीं आता तो आप बहुत ज्यादा स्माइल करते हैं.
All right, sir.
मतलब जैसे आप स्माइल कर रहे हैं वहां तक ठीक है. आई एम सो सॉरी सर, आई डोंट नो. तो वो थोड़ा उसमें आप लगेंगे कैजुअल. डिस्पाइट यू बीइंग ए वेरी सीरियस, वेरी हार्ड वर्किंग एंड वेरी कंसिस्टेंटली वर्किंग अपॉन दिस गोल, आपने बड़ी मेहनत की हुई है, वो नजर भी आ रहा है. आप अगर थोड़ा सा भी इशारा दे देंगे ना कैजुअलनेस का, वो नहीं चाहिए. तो व्हेन यू डू नॉट नो द आंसर, जिस लहजे में आप बोलते हैं ना कि सर कैन आई टेक ए मोमेंट, कैन आई टेक 5 seconds, कैन आई टेक ए मोमेंट, एंड सेकंड्स मिनट्स मेंशन नहीं करने, कैन आई टेक ए मोमेंट.
Sure.
ठीक है. तो जिस लहजे में आप वो पूछती हैं उस लहजे में ही आप मना कर दीजिए कि सॉरी आई डू नॉट नो द आंसर,
All
और आई स्टैंड करेक्टेड, जो भी होगा.
sure,
ठीक है ना.
sir.
बस ये दो ही चीज थे. लॉ अच्छा है. द गुड थिंग इज दैट यू हैव क्वालिफाइड. आपके पास आउट होते भर्ती आ गई, आपने क्वालिफाई भी कर लिया.
लो इसीलिए मुझे लग रहा है कि लो इसीलिए काफी अच्छा है एकमजोत का.
अभी रिसेंटली आपने पढ़ाई की है एंड डिसेंट कॉलेज, यू पास आउट फ्रॉम वेरी डिसेंट कॉलेज, एंड I think I would be hopeful.
Thank you so much, sir. That really means a lot to me. Thank you, sir.
Right? We do not know, but obviously we would be
Yes, sir.
best of luck and
Thank you.
hopeful. हम भी आप भी हैं, हो जाएगा.
Thank you.
Best
All right,
wishes.
जी.
Thank you.
Have
Sir,
a nice time.
to ask something, sir. Sir, are you aware कि भी क्या questions पूछ रहे हैं interviews में?
यही
Oh,
देखो
Mr. Karan.
बेसिक क्वेश्चंस तो यही है, व्हाई यू वांट टू बिकम ए जज, प्लीज इंट्रोड्यूस योरसेल्फ. लीगल क्वेश्चन सिचुएशन बेस्ड भी है, कुछ डायरेक्ट भी है. मैक्सिमम दे आर गिविंग 10 to 12 मिनट्स, दैट्स ऑल.
All right,
और
sir.
आपका कॉन्फिडेंस बहुत अच्छा है, आपकी एनर्जी बहुत अच्छी है ना. मुझे ऐसा लग रहा है आप निकाल दोगे इसको,
Thank you, sir.
क्योंकि हमने काफी सारे स्टूडेंट्स के इंटरव्यू किए हैं. आई थिंक यू आर दी फर्स्ट एंड दी लास्ट जिसको लॉ बहुत अच्छे से आ रहा है, कट 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 कट,
Thank you, sir.
है
Thank
ना.
नहीं और भी हैं मतलब, लेकिन आप भी उन्हीं उसी कैटेगरी में हो.
you.
तो अच्छा है
ऐसा
आपका.
ना हो. अच्छा, पढ़ाई ठीक की है तुमने, काफी काफी डिलीजेंटली आपने मेहनत की हुई है.
Sorry, sir.
काफी डिलीजेंटली आपने मेहनत की हुई है.
Thank you, sir. Sir, any subjects out of the syllabus of Haryana Judiciary which I should study for the interview?
एनआई एक्ट थोड़ा सा देख लो,
Sure, sir. ठीक है.
एनडीपीएस
उसमें भी
देख
चेक
लो,
बाउंस, बस उसमें भी 138.
ठीक
ठीक
है.
है. और ऑफेंस अगेंस्ट वुमेन, ये जो पॉक्सो है आपका,
Yes,
जेजे एक्ट थोड़ा सा गो थ्रू कर लो.
yes, sir.
बट डोंट वेस्ट टाइम अपॉन इट, वो आपका थोड़ा सा फ्री टाइम टाइप्स.
All right, sir. ठीक है. Sure, sir.
ठीक है.
Thank
बेस्ट
you.
बेस्ट.
Thank you, sir.
थैंक यू. कोई और तो नहीं है ना भाई?
नहीं, ये तो भाई साहब